Hey everyone, Harry here to talk about the Supreme Court argument this morning in U.S. versus Jeffrey Fisher, which everyone is watching closely because of its very possible overlap and implications for Trump's charges in the January 6th case. Okay, Fisher is a nasty character who goes to the demonstration, tweets out things like, Congress can't pass the certification if they can't breathe, and we're going to take them out to the streets and have a mob trial and stuff like that. Nasty character who is charged with a number of charges that the Marauders have generally faced, having to do with entering Congress and generally making a ruckus. But one of the charges, and the one that also Trump is charged under, is 28 U.S.C. 1512C, obstruction. And what that statute provides is first of all, it's a pretty hefty penalty, up to 20 years, for doing, it's the statutory language that was the focus of the argument. But basically, if you corruptly impair or destroy or mutilate evidence, and that's the classic instance for 1512C, it's passed as part of the Sarbanes-Oxley law having to do with securities fraud. But then the critical language says, or otherwise obstruct, influence, or impede an official proceeding. And if you think about the words, were guys like Fisher impeding an official proceeding, namely the January 6th certification, or obstructing that official proceeding? It seems in a sort of commonsensical use of the term that sure they were. That was sort of the whole point, is to keep it from going forward. However, that's not the way the statute has been used to date. And this morning, in the opinion, it provoked extreme consternation, I think it's fair to say, it's also fair to say, a majority of the court. So Chief Justice Roberts and Justice Kavanaugh, as well as Alito, Gorsuch, and Thomas, and even Barrett, seem to be given real pause. And their basic concern is that that kind of theory could be used to encompass what's basically political protests. So Barrett asked the United States, the person for the Solicitor General's attorney, what if someone's just standing around on January 6th, but encouraging, the people to go forward? Would that be, officially, otherwise impairing an official proceeding? What if there is a sit-in at a trial? What about, and they're using current events. I'm actually in San Francisco now, where yesterday there was a big protest at the Golden Gate Bridge over the Israel-Gaza war. What about that? Is that count as a some kind of obstruction? What about catcalling or hooting at the State of the Union, an official proceeding? Would that count? So they're obviously worried about the way the application of the law to Fisher could sweep in First Amendment activity, or things that we would think of maybe as even unlawful and that ought to be criminalized, but not the real blunderbuss of this obstruction statute, which has a pretty big penalty. Now, Fisher was charged, and along with all, many January 6th defendants, and the district court, a Trump appointee, threw out the obstruction charge. It then went up to the Court of Appeals, and that court reinstated it. In fact, the opinion by Florence Pan, who is the famous originator of the hypothetical in the immunity case, what happens if there's an order to kill a Navy SEAL. She says, look, it's covered by the plain language. Yeah, it could be, you can see situations where it could apply, but that just means Congress wrote it with a certain breadth. It doesn't mean that there's, anything. The statutory interpretation covers this. And that's when it served up to the Supreme Court and the arguments today. And, this court has narrowed laws in almost precisely this situation, things that could be applied, especially to white-collar defendants, and that might, however, bleed into First Amendment activity. They've shown themselves in the past to be concerned about, and I think the betting odds in the wake of this argument would be the same. That is, that there's going to be they're probably going to strike down the obstruction conviction. Now, let's say they do. What does it mean for Trump? Because Trump, too, the basic charge is that essentially he's really encouraging, inciting, urging on his squad of marauders and hooligans to impede to actually scuttle the proceedings, stall for time, get Pence to change his conduct. There might be a theory that remains if they narrow it. You could try to what I think the court is looking potentially to say is it goes on this otherwise clause. So would otherwise be in a different way you impair the proceeding? That's what the United States is saying. What Fisher is saying is otherwise you similarly do what the phrase before says, meaning basically you mess with evidence. So now if that's the narrowing reading, it's got to be messing with evidence. There is some evidence involved, potentially that's charged in the January 6th case. The phony state representative saying we actually are the delegates for Trump. Maybe the actual piece of paper that Pence himself is opening, but they're not messing with either of those documents or, otherwise changing them. They're rather trying to substitute or keep them from having legal effect. So it seems to me that Trump would have a pretty good argument if the Supreme Court narrows the statute to basically involving destruction of or impairing of evidence, that that specific charge, which is part of the January 6th case, would go away as to him. And of course, it would give rise, probably only on appeal. This probably isn't a delay issue, though he would raise it right away. But he would, be able to say that charge should be excised from the indictment. So that's what the whole focus is. And it is looking like a majority of the court is probably going to do a narrowing construction for Fisher, and that will probably cast a shadow over the Trump charge involving January 6th. We ought to know by around the end of June. The three progressives seem to say, Sotomayor in particular, seem to take the Florence Pan line below of this is what the statute says, go to Congress, not us. But my sense is, and I think the sense of most observers, especially when Chief Justice Roberts expressed concern, is that there will be 5 or 6 votes to say this has to be narrowed, if not struck down, probably narrowed. So that's the Fisher oral argument and the likely opinion, and then it's going to play out in some way involving Donald Trump. But all this is part and parcel of the well down the line, mess in the wake of whatever conviction or result in the trials there will be. It matters, but not in the immediate focus that we all have and will really be applying come next week in the immunity Supreme Court argument as to whether the trial goes forward this year or not. Even if it's decided in June, Trump might raise an immediate motion to dismiss that charge. And the district court could well say, okay, the Supreme Court has ruled, I'll take it out, or not. But that ruling would then stand, whatever it is, their trial would ensue. and that would be one of his arguments on appeal if it goes against him. So I don't see it adding to the delay, but I do see it adding to the overall legal complexities and issues and potential narrowing of the indictment somewhere down the line. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.